Two judges, same crime, but one showed mercy, broken heart. The other demanded justice, fire. Both believed they were right. So, who really made the right call? Watch till the end, and you decide. Balance scale. All right, folks, we're back in court with Benjamin Flannery. Last time, the judge gave him one last shot to stay out of jail. So what happened? Did he turn things around or crash right back into trouble?
We will go on the record in the matters 20 CM 234, 21 CF 130, 21 CM 199, State of Wisconsin versus Benjamin Flannery. The state appears through DOC agent Leah Lineweber. We have Mr. Flannery in person as well. We're set here today for a probation review hearing. We were here on February 19th, in which the court did provide specific orders and conditions for Mr. Flannery to meet to avoid having conditional jail. He was serving some conditional jail or in custody on a warrant and facing conditional jail. At that time, the Department of Corrections had another individual, Gretchen Annabis, in your place, Ms. Lineweber. That is not the agent of record. You were on vacation. And so she had notes about the case, and there was a recommendation from your standpoint and Department of Corrections standpoint. But now you are back from vacation, and you can provide the court with an update on where we are now from February 19th and where Mr. Flannery is and if he is actually meeting the conditions of the court.
He is not meeting the conditions of the court. He showed up on the 28th of February and he admitted to using methamphetamine.
I'm sorry, I have to turn you up a bit. Go ahead.
You want me to repeat?
Yeah, no, you don't have to repeat, but Can you bring the microphone just a little bit closer?
During that office visit, he was told about the GED boot camp. He did fill out the paperwork while he was in the office, and we did email it to the GED boot camp to make sure it got there. He did come back on the 14th, and he was positive for marijuana, and he stated that it was not new use. But I did not realize at that time that he didn't test positive, or he didn't admit to it when he came into the office the first time. So I believe it was probably new use, but he was negative for methamphetamines at that time. He has not handed in any of the job logs, but he did state that he was hired full-time with his wife's uncle, I believe. He was told that he needed to bring in documentation, like fill out the days and the times and have the boss sign it, verifying that that's what he worked. And he was supposed to bring it to court today.
Let's break this down. After being told no drugs, he admits to meth just 9 days later, then pops positive for weed by March. That's not just a mistake. That's a straight-up violation.
Yes, not.
Okay. Mr. Flannery. All right, so you were here in court on the 19th. You then saw your DOC agent on the 28th, and you admitted to consuming methamphetamine, correct?
Correct.
So from February 19th, in which you were in court, and the court set very strict conditions and did not order conditional jail, you used methamphetamine between February 19th and February 28th. Correct?
Yep.
And then between February 19th and March 14th, you used, at least you used THC marijuana, correct?
Correct.
Now, I have a notation that you've paid in your probation cases, is that correct? Have you made any payments?
Yeah.
When did you make payments?
I made, after the first 2 weeks, because you said $50 a week. After the first 2 weeks, I paid 100. I paid 50 last week, and I have 50 this week, Friday.
All right, but you still owe a significant...
Here's the key part. Staying clean wasn't optional. It was a condition of his probation, and the only reason he wasn't locked up back in February. Break that rule, and the judge's hands are tied.
Yep.
All right, you understand one of those conditions that the court did order was absolute sobriety. Understand that?
Yep.
I mean, that is one of the conditions, not only that is part of why you were not ordered for conditional jail on February 19th, but that is one of the conditions for your probation. You understand that? Understand that?
Yes, I do.
Okay. And so now we have 2 admitted uses of not only THC, but methamphetamine. And we're talking February 19th to February 28th is not that long in time, right? Ms. Lineweber, is there a recommendation from Department of Corrections?
There was not.
You don't have a recommendation?
No, I'm sorry. I just assumed we would bring it to you and then you would decide what you wanted to do.
Mr. Flannery, is there anything that you want to tell the court or you want to let me know?
Yeah, I mean, the drug use, I guess I understand it was a rule that I broke, but it was more of a slip up, and I'm doing pretty good.
Your eyes look kind of bloodshot right now.
Yeah, it's windy and cold. I've been outside all morning.
If I get you tested right now, you're not going to test positive?
No.
Saying it was just a slip up, but his eyes are bloodshot, and there's zero proof of the job he claims to have. If you're the judge, do you buy that story?
Okay. What else?
Well, now that I've been working full time, I can make my payments for sure.
And who are you working for?
M5 Construction is the company. His name's Kevin Miller.
Oh, I know Kevin Miller.
Yep.
And who is he to you?
He's my uncle-in-law.
So I have one memorandum from the Department of Corrections from March 17th. I had another memorandum, but I don't know which file that was filed in. But I do remember there was another one filed from a different date prior to the last probation hearing. At least I thought there was. Maybe it was just what Ms. Anubis told the court. Did you file a memorandum prior to the last hearing?
I did, requesting the hearing.
Requesting the hearing. Do you remember what date that was?
I do not. I'm sorry.
Oh, that's okay. Oh, was that in December?
It very well could have been.
Yes. December 23rd, 2024 was a memorandum requesting a hearing. He wasn't paying his fines and fees. He didn't get his GED. He didn't complete the AODA. Oh, that's another reason. That's what we discussed, the AODA last time, and with the absolute sobriety. All right, anything?
This isn't just about drugs anymore. No GED, no AODA treatment, no payments until recently. It's a full list of broken promises, and the judge has clearly had enough.
Mr. Flannery?
I guess not.
All right. Well, based upon what occurred on February 19th and based upon what occurred between February 19th and today, the court is going to order 90 days of conditional jail to start immediately today. You'll be taken up right now. 90 days conditional jail.
Can I get one more?
Nope. You're all done. I gave it to you on February 19th. No. You're all done. 90 days.
Come on. I'm just getting my stuff together. I've been doing.
I gave you leniency on February 19th.
Give me a chance at least to.
I gave you a chance
I know,
on February
but
19th.
Please, come on, please.
I gave you your chance
Judge,
on February 19th.
Please.
You have not done your AODA since I sentenced you, Mr. Flannery.
You said about the AODA.
When did I sentence you?
You said about AODA, remember you said we're going to just put that aside right now and worry about the other stuff. We'll worry about the other things. Okay, so I'll do the AODA.
Nope.
I'll do the AODA then.
90 days.
I'm signed up to do my GED. Your Honor, please, come on.
90 days.
No. Come on, please.
90 days. 100 days.
And there it is, 100 days in jail. From begging for another chance to shouting in court. But after all those second chances, was this the only outcome left? What do you think? Fair or too far?
You just swore. 100 days.
And just like that, we're off to a dramatic start. The judge asks if this is Tiffany English, and she says no. Either she's in denial, confused, or hoping a simple no might magically make the charges disappear. Spoiler alert, it won't. Boom.
Good morning. Are you Tiffany English?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. English, in 18-30705, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation June 10th of 2019 for the offense of assault on a peace officer, a second-degree felony, and that was a 7-year deferred probation. Is that correct?
Yes, ma'am.
And in cause number 19-31722, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2019 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
Hey, Judge, I just want to clarify for the court's knowledge. I spoke with Ms. Cole. That was extended. When I first looked at it, it looked like it was
Okay.
2019, and now it's 25, and it would have been expired, but I confirmed
That it had.
been extended.
Okay, thank you. Each of these cases allege that you violated your probation. Count 1 in each case alleges that you tested positive on a drug patch for tetrahydrocannabinol and cocaine May 8th of 2025. And is that true or not true?
This is the kind of moment probation officers hate. Testing positive for cocaine and THC while already on probation? That's like throwing gasoline on an open flame. It's not just a slip up, it's a straight challenge to the court's mercy. And trust me, the judge is definitely paying attention.
True or not?
Sure.
Count 2 in each case alleges that you failed to provide verification of completing a job search. And is that true or not true?
Yes, true.
Count 3 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
Sure.
Count 4 in each case alleges that you failed to successfully complete the SAFE program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
Count after count, drug use, no job search, unpaid fees, incomplete programs, and Tiffany just keeps saying true. She's not even trying to deny it. It's like watching someone fold their hand before the dealer even finishes the deal. At this point, the only thing holding is the judge's patience.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. English is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. In cause number 18-30705, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your plea agreement to a term of 3 years in the...
Boom! 3 years in the Texas Department of Corrections. This isn't a slap on the wrist. It's a full-blown wake-up call. Assaulting a peace officer is serious business, and the judge isn't sugarcoating a thing. Tiffany had her shot at probation. Now she's got plenty of
Division
time
of the
to think
Texas
behind
Department of
bars.
Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
In cause number 19-31722, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
These 2 cases will run concurrently, which means together at the...
Another sentence, this time 8 months for drug possession. Lucky for Tiffany, it runs concurrently with her 3-year term, meaning no extra time added. Still, 2 separate convictions? That's a huge red flag for any future leniency. The message couldn't be clearer.
I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas.
Yes, ma'am.
Good luck to you, ma'am. You can go back with the bailiff.
Thank you.
Good morning, sir. Are you Shelton Reddick? And will your client waive the formal reading of the indictment?
He will.
Good morning, sir. Are you Carrington Scott? Mr. Scott, in cause number 250538, you're charged with the second-degree felony offense of robbery from March 20th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? And I have here...
Actually, there's some priors that are not listed in the indictment.
Okay.
Yeah, I think
His actual range is habitual.
Okay, and you've gone over that with them, and as notice either has or will be filed of
Notice
those?
will be filed. We'll give oral notice on the record today that he will file notice with intent to enhance his punishment based on his prior convictions. We'll get that in writing and get that filed this morning.
And there's at least 2 prior non-state jail sequenced?
Non-state jails.
Okay. So, Mr. Scott, if those prior convictions are true, what that means is that if you go to trial and you're found guilty, the range of punishment becomes that of a habitual offender, which is a minimum.
Now things get real. Carrington's past is coming back to haunt him. With those prior felonies, he's looking at habitual offender status. That means the minimum starts at 25 years, with the potential for life. No more second chances. This is maximum risk territory.
25 years in prison, up to 99 years or life. Do you understand? I have here on the computer a plea bargain rejection that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be to go, I guess, on count 1 only, and for a 15-year term in the institutional division of the Texas Department of Corrections. That would be to go on the robbery itself without those enhancements for a 15-year sentence. You have every right to reject that and have your case set for trial. I want to make sure you understand what your possible consequences are and what your options are. And you understand all of that. And you want to reject that offer and have your case set for trial.
He just did it. Carrington Scott turned down a 15-year plea deal. That's either brave or reckless. With habitual offender status hanging over him, this trial could go from bad to catastrophic fast. One guilty verdict, and he's staring down a lifetime behind bars.
All right, we'll get that done. Mr. Scott, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, Mr. Rojas, you are released. Mr. Scott, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Good morning, sir. Are you Terry Thompson?
Yes, sir.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Thompson, in cause number 250474, you're charged with the third-degree felony offense of false statement regarding property or credit, and that's from March 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, sir.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thompson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of making a false statement regarding property or credit, sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I didn't go over this as well. Are you a U.S. citizen? Okay. Required to ask. So I will also sign a dismissal as part of this plea agreement in cause number 250475. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. Thank you, sir. Good morning. Are you Winfred Lamont?
Yes, ma'am. Good morning.
See, Mr. Lamont, in cause number 231842, you are charged with the state jail felony offense of unauthorized use of a vehicle from July 14th of 2023. The indictment alleges you were previously convicted of burglary of a building, a second-degree felony, February 9th of 1990. After that was final, you were convicted of unauthorized use of a motor vehicle, a third-degree felony, October 31st of 1991, in 2 cases on that same date, making this for punishment purposes a second-degree felony. And how do you plead to that charge?
Yes, Your Honor.
And are those prior convictions true?
Yes, Your Honor.
I have here, and are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And did you plead guilty because you actually did what they've charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with your lawyer?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1. It's admitted. Is there any evidence that Mr. Lamont is not competent? All right, Mr. Lamont, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of this agreement in cause number 250234. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney.
Yes, Your Honor.
Good luck to you, sir.
What to you also?
Good morning, sir. Are you Trevor Green? And Mr. Reynolds, will your client waive the formal reading of the indictment?
He will.
Excuse me, before we get going, I'd like to point out that the grandmother of the victim is here in the courtroom today, Millie Stoker. She's not only the grandmother, but she's essentially acts as a mother figure for the victim in this case, raising him since he was like 4 days old. 4 days.
Okay.
And I've discussed the plea agreement with her, and she's in agreement.
Thank you for being here, ma'am. All right, so Mr. Green, in cause number 250524, you're charged with the first-degree felony offense of murder from April 28th of 2025. And how do you plead?
Let that sink in. And now Green just pled guilty to first-degree murder. No trial, no defense, no jury, just raw accountability. The weight of that plea is crushing. A choice like this doesn't come easy, especially when a life-changing sentence is right around the corner.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Reynolds? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, State's.
It's admitted. Is there any evidence that Mr. Green is not competent?
None to know.
And Mr. Green was charged as an adult, not certified, correct?
He was charged as an adult.
Okay.
Your Honor.
I was just trying-
There's no certification.
Okay.
He was 17 prior to the election.
Okay. All right then, Mr. Green, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of murder. Sentence you in accordance with your agreement to a term of
30 years. That's 3 decades in prison. No appeal, no second chance, just cold, hard reality. The courtroom's silent, but the weight of that number hangs heavy in the air. One choice, one moment, and a lifetime changed forever.
I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of that judgment against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Reynolds. All right, good luck to you, sir. You can go back with the bailiff. Thank you again.